It's my pleasure to introduce Kristen Henry, who's going to present on ethics of working with clients with diminished capacity. Kristen is an attorney with the Disability Rights Ohio. She leads the Abuse and Neglect team, which investigates abuse and neglect of individuals with disabilities, monitors facilities throughout Ohio, and advocates for clients on issues related to the criminal justice system and guardianship. The rest of her bio is in your folder, so please, at your leisure, read that, but I want to give her the benefit of as much time as possible, so I'm going to hand it off to Kristen.
Thanks, Ruth. Can everyone hear okay with the microphone? Okay, great. Well, I am your half hour of professional conduct CLE today, so you're welcome. As Ruth said, I'm an attorney with Disability Rights Ohio. If you're not familiar with our agency, we are the protection and advocacy system for people with disabilities in Ohio. Federal law requires each state to designate an agency like ours, and so we are available. We have expertise in representing people with disabilities in ADA issues and other things, and we do offer to consult with attorneys. We typically don't represent people in criminal cases, but we do offer to consult with attorneys who are representing people in those cases when they need information about disability rights or how to assist people with disabilities, connections to service systems, and things like that. So my contact information is at the end of the presentation, and I encourage you to reach out to us if you need assistance. So as I get started, I want to clarify how I'm going to use two terms because sometimes we can use them interchangeably. I want to define the difference between capacity, because our ethical rules talk about clients with diminished capacity, versus competency, which is a specific legal standard in different cases. So when I talk about capacity, I am talking about a person's ability to make a particular decision at a particular time. And because of medical conditions, because of mental health conditions, because of sleep deprivation or lack of caffeine, your capacity to make a decision may fluctuate based on what the decision is, based on the time of day, based on the current condition that you're in. And so capacity is something that fluctuates, and we need to keep that in mind because it's very important as we're working with people over a course of time. Their capacity to make a decision, a specific decision on this particular day, may be very different from their capacity to make a different decision on a different day. Competency, by contrast, is a legal standard, and we find that legal standard in a couple different places. For your purposes, you're probably focusing on competency to stand trial. So I've listed the revised code requirements for that, whether the defendant's present mental condition or because of the defendant's present mental condition, not at the time of the crime, the defendant is incapable of understanding the nature and objective of the proceedings against the defendant or of assisting the defendant's defense. By contrast, in guardianship, which I'll talk about a little bit later in this presentation, the competency standard for guardianship is whether the person is so mentally impaired that the person is incapable of taking proper care of the person's self or property. So I encourage you to use each of these terms carefully, whether you're talking about capacity or if you're talking about competency to stand trial or incompetence for the purpose of establishing a guardianship, because those can mean very different things and have very different impacts on the client. This tool that I'm giving you as a resource, it was designed by the ABA, the American Bar Association, for the purpose of assisting attorneys who feel like their clients may need a guardianship or may need some sort of decision-making support. But I also think that it's very helpful to attorneys who are working with clients who have some sort of diminished capacity, because it kind of helps you think through all of the different supports that are available, the different causes of incapacity, and what can be done about that. So the practical tool, practical is an acronym for each of these things I've listed on the slide. We don't need to go into that in detail, but I wanted to make you aware of that resource in case it's something you would find helpful if you have a client who you're deciding whether they need some sort of additional decision-making assistance or whether you need to involve someone else in the representation as the rules allow. So some general principles before I get started is the mere fact that a person has a disability, a mental health condition, an intellectual disability, a physical disability, does not mean that they have diminished capacity and that your representation will be affected in the ways we're going to talk about. Many people with disabilities have full capacity, full understanding, full decision-making capabilities. I also want to be sure we understand that just because a person is making bad decisions doesn't mean that they have diminished capacity. So sometimes when we're working with clients who are going through guardianship proceedings, the focus is on what decisions they're making that someone else thinks is not in their best interest. Well, that's something that we all do, make decisions that are not in our best interests. I'll probably be having a cherry Coke for lunch today. That's really not in my long-term best interest, but I like it and it helps keep me awake for my drive back to Columbus. And if you're representing clients in criminal defense cases, frankly, they are all making bad decisions, right? So they can't all have diminished capacity and disabilities, and we can't treat them all differently. So just because a person has a disability and is making bad decisions doesn't mean that they are incapable of making decisions or incompetent and therefore need some sort of proceedings that are special to them. So as we're representing clients who are making bad decisions, have disabilities, the thing that the professional conduct rules tell us to keep in mind are that we need to maintain a normal client-lawyer relationship with that client. And that means communicating with that client as we communicate with other clients. It means maintaining the confidentiality of that representation with some narrow, specific exceptions that I'll talk about. It means maintaining loyalty to that client and not loyalty to their parents or their service providers or someone else, or loyalty even to what you think might be in their better interests instead of the decision they're making. And it also means giving them your independent professional judgment and candid advice. So even if someone is making bad decisions or is proposing a bad course of action in your legal opinion, you can tell them that. You may, as their attorney, have to go forward with that decision, but you are encouraged, and I would say required, to tell them this is the potential bad result that's going to come if you reject this plea offer, or if you go forward with this course of action, if you decide to testify at trial, things like that. And as we're representing our clients, we need to keep in mind that there are requirements under the law for us to be accommodating our clients. The ADA does apply to lawyers and law offices, and I'll talk at the end of the presentation about some ways that you can be mindful of accommodations for clients. And then I also encourage you, as you're representing your clients, to consider all of the potential impacts of the potential course of action you're taking or of their decisions on the client. One specific thing I would say is we see a lot of clients who end up being found incompetent to stand trial or maybe not guilty by reason of insanity, and they go to a hospital for treatment or care or whatever the case may be. And we see clients who end up spending a considerable amount of longer time in those facilities than they would have if they had just pled guilty or maybe been on probation. So even what may seem like the legally right answer of this person is incompetent to stand trial or this person is not guilty by reason of insanity may not actually be the best impact for the client. So I encourage you to really think through that and to be advising your clients of those issues. Okay, so let's dive into the rules. And I will say this is not how I normally do a PowerPoint presentation. I usually follow the rules about, 4 lines, 5 words per line, but I think it's really important for us to see the actual text of the rules of professional conduct, and then I'm not going to just read them to you and move on to the next slide. I'm going to emphasize some of the things that are in bold there. So we're starting with Rule 1.14, which is when you have a client with diminished capacity. And so here's how the rule starts out. It says, when a client's capacity to make adequately considered decisions in connection with a representation is diminished, and that can be because of minority, mental impairment, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. So there's our general principle. Even when you have a client who has diminished capacity, you are to maintain a normal client-lawyer relationship with that client. So starting out with the assumption that I'm going to interact with this client, I'm going to handle this representation, I'm going to treat this client with the same dignity and respect and decision-making authority that I would any other client that I have. The other point I'd like to emphasize is adequately considered. So that again, we're not going back to judging their decision. That's a good decision, that's a bad decision. It's an adequately considered decision. Can they understand what you're telling them about the pros and cons, about the potential impacts, and weighing those results, potential results, to make a decision? So again, I like to, as I'm talking about decision making, whether it's for presentations like this or when I'm talking about guardianship, sometimes when we're interacting with people with disabilities, we get a little more overprotective, a little more paternalistic, and we say, oh, you know, they can't understand, they're not able to make the right decision. Well, again, think of like your black sheep sibling. I like to talk about my sisters because they never come to these presentations and they'll probably never find out. My sisters are a few years younger than me, they're twins. They make a ton of really bad decisions. But, you know, if they had a lawyer, the lawyer would be following what they tell them because they don't have disabilities, so there's no excuse not to follow what they're saying. And so when you have a client who has a mental illness, an intellectual disability, whatever it may be, you know, don't focus on the disability. Focus on this particular issue. Are they understanding what I'm communicating to them? Am I communicating it well to them? And are they making a decision that makes sense to them? Is it adequately considered? So that's rule A. Oh, yeah.
Real quick question. In that regard, then, if you counsel the client, if you're going to do something that you don't think is in their best interest, but as you said, you've taken all these factors into consideration, do you ever have them sign something that says, I understand my lawyer's explained this course of action, I choose to do this instead, sign? So at least you have something in writing, and so they can't come back and say, my lawyer never told me this, that, or the other thing.
I think that's a great idea, and I think that's something that probably attorneys do with other clients who are making bad decisions, you know, whether it's rejecting a plea offer so you can be prepared for that hearing 2 years down the road that you never told them about the plea offer, or you never told them about the consequences of maybe being deported, things like that. I think it's a great idea to document those things so that there's a record later on. And for the client's records too, because maybe if they do have times where their memory isn't as good, so that they have that record in their own copy of the file that, yes, we did talk about it and this is what I decided. Okay, so then let's move into B, because B is where we get a little off the normal lawyer-client relationship. When the lawyer reasonably believes that the client has diminished capacity, is at substantial physical, financial, or other harm unless action is taken, and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. So this is where we get into this kind of different territory, that if you have a client whose disability is so affecting their ability to make decisions, their capacity, and it's going to substantially affect them in some way, and they're not able to act in their own interest, then the rules do allow us to take some sort of, what it says, reasonably necessary, so not just whatever the broadest action might be, a tailored action, which may be consulting with professionals, like the professionals you're going to hear from today, or other entities that might be able to help the person. And they say it can go so far as trying to get the appointment of a guardian ad litem, someone who can help advise the court about the client's best interest, a conservator, which would be a voluntary decision-making surrogate, or a guardian, someone appointed by the probate court to act in the client's best interest. So those are possibilities, but then that practical tool I talked about at the beginning of the presentation, that's something the ABA has developed specifically for situations like this, so you can consider some of the less restrictive alternatives. So then you may ask yourself, well, how can I balance the normal client relationship, the confidentiality, with a decision that I need to take some sort of protective action for my client? And that's where 1.14C comes in. Information relating to the representation of a client with diminished capacity is protected by Rule 1.6, the confidentiality rule. But When taking protective action pursuant to Division B, the lawyer is impliedly authorized under Rule 1.6a to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. So maybe you feel like you need to consult with some sort of mental health professional to get an outside and independent opinion about your client's capacity to make these decisions. To the extent reasonably necessary that you need to divulge that confidential information, these rules would allow that to happen. Rule 1.6a says that you have to keep everything confidential unless the client authorizes it, or if it's impliedly authorized to carry out the representation. So this 1.14c kind of broadens that scope a little more than you might have initially thought to allow the revealing of confidential information in these circumstances. So thankfully, in the rules of professional conduct, we've got some commentary that digs a little bit deeper because some of that's a very high gloss and it's a little unclear how it would apply in individual situations. So I'm going to go through a few of the comments that I think are pretty helpful. The first point emphasizes what I was saying about the difference between capacity and competence, and it emphasizes that even clients who may have very significant impairments often can make decisions affecting their own well-being. So it's very different to decide what to eat for dinner today than to decide maybe should I take this plea offer of 20 years in prison when I'm facing 30 years in prison, for example. So a person may be able to make those lower level, what the comment calls routine decisions versus major transactions. So it's good for you to be assessing what kind of a decision am I asking this person to make, and would they maybe have capacity to make this decision and struggle to have the capacity to make a more complex decision. Comment 2 emphasizes maintaining that normal client relationship, and it especially emphasizes having communication with the client. So even if you have a guardian involved, even if you have some other reason to suspect the client can't be fully involved in the decision making, communicating with the client about the status of the case, the options that are available, what's going to happen in the case, you still have that expectation under the rules. The third comment is something I really like to emphasize, but it's important to be careful and also important to document in case there may be a problem down the line. So generally, you know, the attorney-client privilege only applies communications with your client. What this comment says is, if you need to involve a family member or another person, maybe a service provider who's very familiar with the client, that does not affect the attorney-client privilege when it's necessary to assist in the representation. So a classic example of this would be if you have a client who's deaf and you use an ASL interpreter, that communication is still protected by attorney-client privilege even though you have a third party there. Some people may not need an ASL interpreter, but they may need a family member who is familiar with their communication style. I have to strongly, strongly emphasize the need to document the necessity and the decision to include that third party. You can't just assume that there will be blanket protection. We have heard of some courts, not in the criminal context, but in other cases, who did not apply this rule, I think incorrectly. But that basically just emphasizes the need that if you're involving a family member and you think this communication could be something that someone might try to bring up later on, if it really needs to be protected, make sure you're documenting, make sure you're informing the family member of the confidentiality requirements and all of that. And then this comment also emphasizes that even if you do have to involve a family member or another person, the decision comes from the client. So same as if you have representation that's being paid for example, by a family member, you're still taking direction from the client. The same applies here. Okay. Comment 4 goes more to if a guardian is involved and directing those decisions. So I think that's something that probably doesn't come up in as many of your cases, so I won't go into that into too much detail. I will emphasize that the comment says that the duty to report illegal actions by clients would apply here if a lawyer representing a guardian was aware of actions that were adverse to the ward. So comment 5 starts to dive into that 1.14b, the protective measures issue, and it tries to go through a spectrum of less restrictive to more restrictive actions that you might take if you needed to do some sort of protective measures for the client. So less restrictive would be just consulting with a family member or someone else. Providing a reconsideration period. So this could be something where if someone is maybe struggling with an aspect of their condition, maybe due to a medication change or maybe due to some additional stressors in their life, recognizing that maybe that's not the day and time to ask them to make a major decision, and saying, if it's possible, based on the timeline of the case, based on the status of things, to say, why don't we check back in a week and we'll talk about this decision and have you make that decision then. Or if having that additional time to think through things, maybe having a set procedure with the particular client that, okay, we're going to reach a decision today, but then I'm going to wait to act on that for 2 business days to give you a little extra time to think about it. Any kind of reconsideration period like that. The comment then emphasizes assisting the client with using voluntary decision-making tools like powers of attorney, conservatorships, advanced directives, things like that, before going to the next step, which would be calling like adult protective services or having someone initiate guardianship proceedings. This also emphasizes that as you're considering protective measures and also as you're considering whether the client is making adequately considered decisions, consider what you know about the client's wishes, their values, their interests, what the least restrictive options are, how their capabilities can be maximized. So how can we take their strengths and allow them to use them instead of just focusing on their weaknesses, and respecting their connections, whether that's relatives or families or roommates or service providers, things that they have available to them in the community. So as you're assessing the client's capacity and whether you need to take any sort of action, consider, again, we can't just focus on, is this a decision I consider good or bad? We often disagree with our clients about the decisions they make. But can the client show that they are adequately considering this decision by articulating their reasoning? Maybe it's not a reasoning you agree with, but by articulating, well, this is what I've determined. I think it's better to accept this plea and have this kind of probation versus to risk this other sentence. How are they reaching that decision? Basically, how are they showing their math on that decision? Consider the variability of their state of mind. So is this something where each time you talk to them you get a different answer, or despite the fact that you don't agree with the decision, you're hearing the same answer over and over? It's not something where they're changing their mind. Do they appreciate the consequences? If they're choosing to go to trial, for example, do they understand, can they articulate back to you the sentence they're risking by rejecting the plea offer? What is the substantive fairness? So if they are trying to protect a family member, if they're trying to ensure that maybe services are in place for a child or something like that, is there another kind of justification behind their decision? And is it consistent with their long-term commitments and values? Something that you might know about the client. Is it consistent with maybe their religious preferences, maybe their cultural preferences, things like that? And then again, the comment emphasizes that when appropriate, you can seek guidance from a diagnostician. Now again, revealing the least information you have to. So maybe you don't have to provide the client's name and all of the details. Maybe you can consult on a more anonymous basis with a professional. I think that the appointment of legal representatives is unlikely to occur in criminal cases, but it's important to be aware because this could even go for things like guardians ad litem, who a lot of courts favor, but others, or sometimes the clients themselves, wish that a guardian ad litem had not gotten involved. So considering things like whether the appointment of the legal representative is necessary to protect their interests. And keep in mind that often the law on appointment would require the less restrictive alternative, like a guardian ad litem, instead of a full guardianship. Okay, so let's spend just a couple minutes, I know we're about done here, on that allowance of disclosing information. What I find entertaining about this rule comment is that it says, we've put you in an unavoidably difficult position by saying that you can reveal this information if you need to. It does emphasize that you need to consider to what extent the revealing this information might adversely affect the client's interest. So for example, if the court or if service providers or someone else becomes aware that you think your client is, their mental health is declining, you're hearing some very concerning things maybe about self-harm or harm to others, keep in mind what the consequences for that client may be, and then you have to balance that. Maybe the things you're hearing are so serious that an involuntary commitment would be necessary, but you shouldn't do that lightly, and you should make sure you're considering all of those potential consequences. And then again, the comments continue to emphasize only revealing what is reasonably necessary and considering what the adverse consequences will be when the person you're revealing that information to gets the information. Emergency legal assistance, I suspect it's not coming up in a lot of your cases, but do keep in mind that the rule comments here say that if you're faced with a person who, because of their condition, truly can't give you any sort of direction, they have seriously diminished capacity, but they're facing a situation that would be imminent and irreparable harm, you can, as a lawyer, step in and provide representation if there's no other agent or representative available. You're supposed to only do what's necessary to maintain the status quo. So maybe that's a case where you've been working with a client and then suddenly their condition changes seriously for the worse, and you can't get direction about seeking a continuance or going forward. I would suggest that seeking a continuance to kind of get the case pushed back, to allow more time for the client's condition to be addressed, that would be an example here of taking action to maintain the status quo. You have the same responsibilities as a regular attorney-client relationship, and you have to disclose the nature of this relationship, that you're acting without specific authority to the tribunal, and not seek compensation for that unauthorized representation. Okay, so that's what the rules say. I think that gives us a good framework for kind of the baseline of interacting with these clients as we would any other clients that we serve, and then what options are available to us if we really find ourselves in difficult positions. So the last thing I want to emphasize is how we as attorneys can accommodate our clients with disabilities. The first thing I like to say is don't assume. Don't assume that you know how to interact with this client who has a disability just because you've interacted with someone else who has a disability or even a similar condition. Ask the client what works best for them. Maybe someone who has memory issues because of their condition, they like to have things written down. Other people may like to use voice recorders or things like that. So ask them what works best for them. The law has an emphasis on effective communication, whether that's interpreters, and I know we like to usually think of people with disabilities in categories, like this is a person with mental illness, this is a person who is deaf, but as it turns out, people can have more than one condition, so you may have a client who both needs an interpreter of some sort and also other accommodations for a mental illness. Consider whether assistance from others is how you can get effective communication. Auxiliary aids, like maybe typed communication or phone relay services, having audio-visual materials, like having things written down, maybe diagrams of certain processes if they're hard to follow. And then we also encourage you to make sure you're advocating for the others involved, the court, to be providing those same accommodations that the person might need. All right, so that's your half hour of ethics. If there's any questions, I can take them, but if not, then I will introduce your next speaker. Any questions? All right, well, you will next be hearing from Dr. Stephen Knopfsinger, who is an Associate Program Director for the Forensic Psychiatry Fellowship at Case Western Reserve University, a psychiatrist at the Cuyahoga County Court of Common Pleas, forensic psychiatry consultant for the Ohio Department of Mental Health and Addiction Services, a forensic psychiatrist for Stephen Knopfsinger, MD, Inc., an associate professor of psychiatry at Case Western Reserve University School of Medicine, and a senior lecturer, adjunct faculty at the University of Akron School of Law. And he will be talking to you about legal and competency issues, concerns, and updates.
this goes, just $2.
Yeah.
All right, well, good morning. Can you hear me all? Loud enough? All right, well, my name is Steve Knopfsinger, and I'll be trying to fit about 10 to 12 hours worth of material in the next 2 hours. So I apologize if it's going to feel like this, but ordinarily I cover this material in my law school course over the course of 5 or 6 weeks. So I apologize if I go rapidly here. And we're going to hit a number of these topics here. Competence to stand trial, some of the other criminal competencies like competence to confess and competence to waive appeals. We're going to spend a fair amount of time on not guilty by reason of insanity, both the evaluation of insanity and then what happens after a finding of insanity. We'll touch briefly on the juvenile issues, which is the standard for juvenile competence to stand trial. We'll talk about how mental health professionals can be helpful at the mitigation phase. We'll talk about involuntary treatment, and somewhere in there we'll have a break for lunch. Then we'll talk about mental health courts and the assisted outpatient treatment. And finally, if there's time, we're going to talk about how you might cross-examine a mental health professional whenever some of these issues come up here. Let's first start off here, though, with a pre-test. Test your knowledge on a few of these issues here. So, a defendant who is incompetent to stand trial for murder may have the charges dropped based on his incompetency. Who votes for true? A couple of you. Okay, so I would assume the rest of you vote for false. Question? Well, actually is true, and we'll talk about the reason for this here shortly. Number two, a psychotic defendant who is incompetent to stand trial for murder may refuse medication to treat his psychosis. True or false? Majority says true, and you're correct. A defendant who's incompetent to stand trial and fails competency restoration may still proceed to a trial. In Ohio, we actually have something called ISTU-CJ, which is not, and we'll talk about this here later, but actually is true. There's actually a mini trial they can still proceed to. Someone found not guilty by reason of insanity for murder can be released back into society. Here in a mixed response, that's true. John was found in GRI in a murder charge. He can only be committed if he is presently mentally ill and dangerous. That's false, and we'll talk about that under the Burton standard for commitment. And finally, someone who's found in GRI on grand theft of a motor vehicle will stay under the jurisdiction of the trial court for the rest of his life. You get that one right, false. All right, now I'm going to play a short video, since this is a room full of defense attorneys, a video of some good defense cross-examination of a mental health expert. A time to kill.
Just a few questions, Your Honor. Doctor, who do you work for?
State of Mississippi.
You're 11 years working for the state. How many times have you testified in trial for the insanity defense review?
This is my 46th trial.
Well, those 46 trials, how many times have you testified that the defendant was legally insane?
Objection, Your Honor. The good doctor cannot be asked to recall
All of his testimony of his previous trials is absurd. Thank you.
I can't remember.
Could it be, Doctor, that the reason you can't remember is that in 11 years and 46 trials, You never have seen a defendant whom you have found insane.
I can't recall at this time.
Can you recall testifying at trial one Dan Baker?
Objection, Your Honor. This has nothing to do with proceedings here.
Thank you, Your Honor. Once again, you recall testifying at the trial of one Dan Baker, a rather brutal double homicide where you found the defendant legally sane?
Yes.
The senior psychiatrist disagreed with you, Doctor. Mr. Baker was found insane and institutionalized. Where is he currently, Doctor?
At Whitfield.
And who is the chief psychiatrist of Whitfield? You are. Dr. Rodeheaver is the chief psychiatrist of Whitfield. Now help me make this clear to the jury, Doctor. In 1985, you testified that Dan Baker was legally sane. The jury disagreed with you, and Mr. Baker was found not guilty by reason of insanity. Since that time, he has been a patient in your hospital under your care as a paranoid schizophrenic. Is that correct, Doctor?
Yeah.
Do you normally admit patients, keep and treat them for 10 years if they are sound mind and body?
Of course not.
It would be fair to say that you find insane people sane for the purposes of trial.
Objection, Your Honor. This is argumentative.
Withdraw the question, Your Honor. No further questions.
All right, so Matthew McConaughey makes some good, scores some good points there. All right, well, let's first talk about competence to stand trial. And any talk about competence to stand trial must be preceded by a discussion about competency in general. So competency in general means the capacity to understand a concept and then to rationally proceed through the process of making a decision. And we're not so much concerned, although it's one factor, what the person's actual decision is, but rather the quality of thought that underlies their decision. Competency is also a present state evaluation, so someone's competency can fluctuate over time. Just because someone has a mental illness does not, on the face of it, mean that they are incompetent. You can be floridly mentally ill and still retain your competency if your symptoms don't impact the areas of mental function required for competency in that area. Now, there's more than 30 different types of competency defined in the law, one of which is competence to stand trial. So competence to stand trial is guaranteed by two principles in the U.S. Constitution. The 14th Amendment, which guarantees fundamental fairness through substantive due process of law, and also the 6th Amendment here. And I'm sure you're all familiar with this, but so we have, a defendant must be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel. So if someone is experiencing a mental disorder that makes them unable to work with their attorney or to confront their accuser, then they are effectively denied their rights under the 6th Amendment. Now, the U.S. Supreme Court rendered a decision in 1960 in the Dusky case, in which they gave a standard for competence to stand trial that all jurisdictions followed in, not so much in language but in spirit. And so the Dusky standard for competence is that the defendant must have a sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational and factual understanding of the proceedings against him. So this is the most quoted standard in this country for competence to stand trial, although it was superseded in federal courts in 1984. Here's the Ohio standard. So a defendant is presumed competent to stand trial unless it's proven by a preponderance of the evidence in the hearing that because of his present mental condition, he is incapable of understanding the nature and objectives of the court proceedings or of assisting in his defense. So compared to the Dusky standard that did not require a present mental condition, in Ohio, as in other states, you must have a threshold of a present mental condition. So here's the summary of the Ohio standard. There is a presumption of competence to stand trial. The defense bears the burden of proving incompetence by a preponderance of the evidence. Once it's raised as an issue, the court must have a competency hearing, and any incompetence must be due to a present mental condition. In the past, someone could be found incompetent, for example, due to being deaf, but that's been taken out of the law. So here we are again, just a summary of the standard. Due to a present mental condition. But what does that word mean, present mental condition? It really is a legal term of art the courts are open to interpret. And they have held in general that psychotic disorders and mood disorders and intellectual disability would suffice as a present mental condition as a basis for a finding of incompetence to stand trial. So the present mental condition is contrasted with, for example, in the DSM-5 where we have mental disorders. So a present mental condition does not necessarily equate with a DSM-5 mental disorder. Likewise, to be civilly committable in Ohio, you must have a, quote, mental illness, which means something different than a present mental condition. And then finally, for the purposes of legal insanity, you must have a severe mental disease or defect, which can be different than a present mental condition. So the point is that these are all legal terms of art that courts are open to interpret. Two arms of the test, and a person can be found incompetent if there is a defect in either arm of the test. Either they are unable to understand the nature and objectives or unable to assist in their defense. They don't need a defect in both arms. Now, this slide contrasts these two terms that the media and even courts confuse on a regular basis, competency and sanity. They mean very different things. So competency is based on a present state assessment, and in the construct of competence to stand trial gets to is someone triable. In comparison, sanity is an assessment at the time of the offense itself, going back in time to determine the defendant's responsibility for their actions. So they mean very, very different things here. Let's go walk through the various steps that happen whenever the competency issue is raised. So the defendant is arrested, they're arraigned, and at some point the competence to stand trial issue is raised. Usually by defense counsel, but it can be raised by the court itself or even the prosecutor. Now, research has shown that defense counsel from 8 to 15% of cases questions their client's competency. And typical reasons for questioning their client's competency would be the defendant who has a mental health history, they have treatment for a mental illness, they behaved bizarrely during the offense, or they're behaving bizarrely in their interactions with the attorney. So the competency issue is raised, and then they undergo a competency evaluation at a forensic center. So in Ohio, we have the 88 courts of common pleas. I believe we have 10 or 11 different Ohio forensic centers that do nothing but pretrial competency and sanity evaluations for the courts. So for example, in Summit County, we have the psychodiagnostic clinic that serves a 5-county area. In Cuyahoga, we have the court psychiatric clinic that just serves Cuyahoga County. Franklin County has net care, etc. So once the issue is raised, the court will order a competency evaluation, and these occur at one of these forensic centers. So competence to stand trial evaluations are one of the most common evaluations done by forensic mental health professionals. Approximately 70,000 are done every year in this country. Most are done on an outpatient basis, and I'll talk about it in a second. Well, actually, I'll talk about it now. There is a provision in the statute, and I think someone had a question about this earlier, for an inpatient evaluation. So if the outpatient evaluator at the forensic center is unable to conduct the evaluation in the office setting, then the statute allows for a 20-day inpatient competency evaluation. And the two most common reasons for that is either a defendant is uncooperative or there's a suspicion of malingering. And so we need more data than we can gather in that single office encounter in order to opine on the issue. So once they're in the hospital, they're observed, round the clock by nurses and other hospital staff, so there's a lot more data that we can get in the inpatient evaluation. Courts accept the finding of the competency examiner at a high frequency. Approximately 90% of the time, both defense and prosecution will stipulate, and therefore the court accepts the findings. But it can be contested, and you can have multiple opinions. Now, on average, 30% of defendants that are assessed for competency are opined to be incompetent to stand trial. So 30% is the number on that. Well, how do we evaluate competence to stand trial? Well, we first of all, as a mental health professional, I want to look at this person's past mental health records, looking for a diagnosis and what that diagnosis is. Is there a history of depression, of psychosis, of malingering, of sociopathy? And I want to have a good idea what that is. It would be unusual but not impossible for a defendant with no mental health history to now be incompetent to stand trial. And I would also possibly want to speak with the referring attorney about why they sought a competency evaluation. So again, common reasons for defense attorneys referring people is a history of mental illness, the bizarre nature of the offense, the client now is difficult to work with, or they're making bad decisions or decisions that appear to be irrational. So when doing these evaluations, we do what we do in any kind of standard psychiatric interview, and I think Dr. Stankowski went through this. So we get their chief complaint and their history of their present illness. We get their background histories. We do our own mental status examination. And in the end, take the information gleaned in the interview and the record review and formulate a diagnosis. And then we do what's called a competency evaluation that I'll run through the elements here shortly. Now, some examiners also administer a competence to stand trial assessment tool, of which there's about 15 of these out on the market. And they can be an adjunct to the competency evaluation, but they are not dispositive. So you might see them used, but some don't. And then we take all this information and hopefully formulate this into a well-reasoned opinion that's expressed in a written report. So again, here's a standard, two arms of the standard, and let's look at the various elements that go into these different arms of this standard. First of all, under nature and objectives of the court proceedings, does the defendant know what they are charged with? Do they understand the severity of the charge? Do they know that they're the defendant on trial for the charge? Do they have an appreciation in general what the possible sentence is? Do they understand the pleas available to them, guilty, not guilty, no contest, insanity? Do they understand the roles of the courtroom personnel, so defense attorney, prosecutor, judge, jury, witness, etc.? And do they understand the trial process? So on the first arm of this test, usually we see defendants with low IQ who have difficulty understanding this information as a basis for their incompetency. Somebody with an IQ of 55 might not be able to understand what the different pleas are, or who does what in the courtroom, or the adversarial nature of a trial process. In contrast, if I have a defendant who's got a single delusion that the court has no jurisdiction over them, or that the judge is Satan, that might impair their functioning under this first arm of the test. Now, I would contrast that with a free man who's got a culturally held belief, at least a subculturally held belief, that the law doesn't apply to them or the court has no jurisdiction. So that's not really flowing from a present mental condition, it's flowing from some odd beliefs, but because they're part of that person's subculture, could not be the basis for incompetency. All right, so you know you have trouble if this is what happens when you go to court here. Let's go on now to the second arm of the test, their ability to assist in their defense. First of all, is the defendant able to work with their counsel? If someone's got a paranoid delusion about their attorney, or just paranoia in general, where they don't want to talk with their counsel, that could make them incompetent under this arm. Do they understand what a plea bargain is? You know, a plea bargain is a pretty abstract concept. So they have to have sufficient intellect and judgment to comprehend in general what a plea bargain is, and then to make a rational decision about a plea bargain. Are they able to give a logical, well-organized account of the offense? Because that might result in an alibi or a plea of insanity. Now, they can give a very psychotic account because maybe they had a psychotic motive or symptoms that were present during the offense, which is fine, but they have to be able to give a consistent, rational, well-organized account of the offense to their attorney that then may help in their defense. To be able to testify on their own behalf. If someone is real disorganized, or they're paranoid about the jury, or they're manic, that would impact their ability to testify. Are they willing to consider pleading insanity if it's relevant? Lack of insight can be a key symptom in some defendants with a psychotic illness. So they might, because they fail to recognize that they're ill, then irrationally refuse to consider pleading insanity. Now, there is some case law. There's a U.S. Court of Appeals decision called Friendak from 1979 that says that a court may force a defense of insanity on an unwilling defendant if he is otherwise competent. That's one issue. More things to look at under the second arm. Do they have sufficient memory and concentration to pay attention at trial? Somebody with dementia, someone who's very depressed and can't concentrate, may have problems paying attention and helping their attorney at trial. Are they able to understand and carry out the appropriate behavior in the courtroom? Someone who's manic, who can't keep his mouth shut, or wants to pace around the courtroom, would likely be incompetent under the standard. Now, I would contrast this with someone who chooses to be belligerent or not cooperate, as opposed to someone who can't cooperate because of mental illness. Are they free of self-defeating behavior? Some defendants, either due to depression or psychosis, are seeking conviction, and so are not willing to work in their legal best interest. I had a case about 20 years ago of a woman who drowned her 2 children in a hot tub in the midst of a psychotic depression. And she was seeking conviction and capital punishment because she believed that she should be punished. And secondly, she was hoping to receive a capital sentence so that she could be rejoined in heaven with her 2 dead children. So she was not willing to work with her attorney, and she was incompetent on that basis. Are they able to evaluate the evidence for and against their case, then use that to develop a reasonable estimate of the chances of conviction, and then use that to, with their attorney, develop a basic plan of defense, and then make a rational decision about their defense. So if someone says, yeah, you know, there's all kind of evidence against me. You got my confession, you have the witnesses, the fingerprints, and the videotape, but there's no chance of conviction, therefore I'm not taking a plea bargain. If that's based on a present mental condition, then that could be a problem with their competency. So here's a picture of a client with his counsel. Hopefully they're working together. All right. So what do you do with a client who is not willing to work with his attorney, not willing to trust his attorney? And you have to distinguish this between someone who really is paranoid, and that's the basis for the lack of cooperation, versus some defendants don't trust their attorney because they believe, well, you know, defense attorneys, they work for the court, they work for the county maybe, they're all in league with the judge and prosecutor, and so they just don't trust people. And so I would distinguish that from someone who's truly mentally ill versus someone who's been through the system 10 times before, has heard stories about public defenders in the jail pod. So I would just think of those things as being different. All right, common reasons for incompetence. Low IQ or dementia that impairs someone's understanding under the first arm of what they're charged with, the pleas, trial process, etc. Second would be someone who's depressed and is not willing to work in their best legal interest. Mania, where they can't pay attention or behave in the courtroom. Paranoia, where they can't work with their attorney. Or disorganized thinking, where they can't pay attention. Bad decision making, whether it's due to psychosis, mania, depression, or low IQ. And finally, someone who's psychotic and hearing voices or seeing visions that are distracting at trial. Now, males and females are found incompetent to stand trial with equal frequency. The reasons for incompetence varies with age. So with young defendants, it's typically due to low IQ. With the geriatric population, it's due to dementia. And then young and middle age for all the various reasons, including psychosis and depression. And this is interesting here. Of those clients with a valid psychotic disorder, about half, 45 to 65%, were found to be incompetent. So the flip side of that is, if my math is right here, 35 to 55% were found to be competent. So an illustration of just having the present mental condition does not automatically render someone incompetent to stand trial. And likewise with depression, mania, and low IQ. All right, back to our a description of the chain of events here. So the person has their evaluation at the forensic center, and if the opinion is that the person is competent and the court adopts it, then they proceed to trial. This has just been a brief detour on the competency route. However, if the opinion is and the finding is that the person is incompetent, then we have to have some additional findings. First of all, is there a substantial probability that the defendant can be restored to trial competency? And in Ohio, the test is, can it be restored to competency within 1 year given treatment? And we'll talk about this in a second. There's a Supreme Court case called Jackson v. Indiana. That's the basis for this. So if they're incompetent, are they restorable is the next question. And then finally, what's the least restrictive treatment setting for competency restoration? If they're incompetent and unrestorable, we'll talk about that in a second. So the incompetent, restorable defendant, we then have to figure out what's the least restrictive setting, and they go to a restoration program. Now, most people go to the state hospital. Most people go to the medium security hospital like Heartland down in Massillon or North Coast up in Northfield. So it's a civil hospital. There's no armed security. There's no chain link fences. There's only about 3 or 4 doors between the inside of the ward and outside of Freedom. But the vast majority go to the civil hospital. There are provisions to send people down to Columbus to the state's maximum security facility at Twin Valley, where they have razor wire, they have many more locked doors between the inside and outside. They have COs from ODRC help provide security. And the reason to send someone down to maximum security is either they're a high risk for escape, or they're so violent that we're concerned about them causing violence in the hospital. So the higher staff-to-patient ratio in the COs will be a factor to address their violence risk. Now, some counties have an outpatient competency restoration program for people on bail. This is usually for people with nonviolent charges who really only need training, so that because of low IQ, they are not competent. So the competency treater then has to provide updates to the court, either when they opine the defendant is now restored to trial competency at a 6-month interval, or when the maximum time frame for competency restoration expires. And we'll talk about that in a second here. So competency restoration involves a 2-pronged approach. We treat the underlying mental illness. So we treat people with psychotic disorders with medication and rehabilitation. Likewise, with depression and mania, we treat them mainly with medication. Then we also provide an educational component. So they're given lectures on how a courtroom works. They go through mock trials. They watch court TV. They have readings. It's a whole educational component to this. Now in Ohio, there is a limit for the time for competency restoration based on the severity of the offense. So F1s and F2s, there's a maximum time of 12 months for restoration. Lower level felonies, 6 months. For M1s and M2s, 60 days, and for M3 and M4, 30 days. Now, other jurisdictions differ from this. In some states, the maximum time is 6 months. Other states, it's 2/3 of the maximum sentence if convicted. In some states, it's equal to the maximum sentence. And in some states, it's actually indefinite. So it just depends on the jurisdiction. Now, even though this is the maximum time frame allowed, in general, the average defendant takes about 12 weeks for competency restoration. And we're pretty successful. For felonies, because we have a bit more time, about 90% are restored to trial competency. And for misdemeanors, because we have less time, it's about 75%. But in general, the vast majority of people found to be restorable are in fact restored to competency. And up here to 9 in, so if they're restored, they're back on the track towards trial. Now, if they're unrestorable, and you can become unrestorable in 2 different ways, either the defendant was found to be unrestorable right off the bat when they were first opined to be incompetent, or they're one of those 10 to 25% of those that fail restoration. They can be found unrestorable when the time frame for restoration expires. So major things happen when someone is found to be unrestorable. The big one is the charges are dropped. And that's pretty big for a serious felony, right? People don't like that. Charges are dropped, and then they can only be retained in the hospital if they meet the criteria for commitment through the probate court. So the case is transferred over to the probate court. I think the statute says the prosecutor files the affidavit, but usually the hospital goes ahead and does it. But just because the charges are dropped does not mean that they are never going to be charged in the future. Because if they're retained in the hospital under a probate court commitment, then the hospital, whenever they're considering discharge of the patient, has to give the prosecutors 10 days notice, and the prosecutor has the option to re-indict at that time. Usually it doesn't happen on misdemeanors and lower level felonies, but a serious felony, ordinarily prosecutors will re-indict. We had a guy one time who in 1984 was charged with 3 murders, and he was incompetent, failed restoration, was in the hospital for 10 years as an ordinary probate court commitment. I think the charges occurred in 84. And in 95, 11 years post-defense, in the hospital for all that time, the hospital then made plans to discharge him. And of course, the prosecution re-indicted. He was re-examined for competence to stand trial, found competent, and tried in March of 96, so 12 years after the offense. He was found to be insane, by the way, and is still in the hospital. But the point here is that just because their charges are dropped does not mean that they won't be charged again in the future here. So back to our pretest question here. This is the basis for someone who is incompetent and unrestorable can have the charges dropped. And this, I think, gets to your question here about no information gathered in the competency evaluation can be used to prove guilt. And just to show you that I'm trying to update my slides in real time, I actually found that it's 2945.371J. So no statement that a defendant makes in an evaluation relating to his competence to stand trial or mental condition at the time of the offense, so that's a not guilty by reason of insanity evaluation, shall be used against the defendant on the issue of guilt in any criminal action or proceeding. So this is not in your handout. But the prosecutor or defense may call as a witness any person who evaluated the defendant or prepared a report pursuant to a referral under the competency or sanity. So they can be called to testify on the competency or sanity issue, but not to provide evidence during the guilt phase. Let's talk about some of the case law underlying competence to stand trial here. So we have Jackson v. Indiana, a case from 1972, U.S. Supreme Court. We have a man named Theon Jackson who had low IQ, but also was deaf and mute. And he had 2 charges of petty theft. He stole items worth $9. At that time in Indiana, if someone was found incompetent to stand trial, as Jackson was, he was sent to the state hospital until such time as he was made competent. So he was sent to the hospital, and after a few months, the hospital wrote back to the court saying, listen, because of his low IQ and because he's deaf and mute, we can't make him competent. And the trial court said, well, my hands are tied. Under the statute, he must stay there until he's made competent, which in this case would have been basically a lifetime sentence in the hospital for 2 counts of petty theft. So this was appealed to the Supreme Court, U.S. Supreme Court, and they said that due process requires the nature and duration of commitment bears some reasonable relation to the purpose of the commitment. So in Jackson's case, the purpose of his commitment was competency restoration. But if we know he can't be made competent, then there is a disconnect and there is no reason to have him go to the hospital. And this is where this concept of restorability comes from. So in order to send someone to the hospital for restoration, there must be a substantial probability that they can, in fact, be made competent. So this is a speculation or extrapolation into the future about someone's potential for restorability. Wilson v. U.S. deals with a defendant who claims amnesia for the offense. This is a case from the U.S. Court of Appeals in 1968. And basically it said that in an otherwise competent defendant, amnesia for the offense is not a barrier to trial competency. Instead, they said the trial should proceed, and then if there's a conviction, the judge will hold post-conviction proceedings to determine the following factors: the extent the amnesia impaired his ability to consult with his attorney and to testify, the extent that the evidence could be reconstructed extrinsically, and the extent that the prosecution helped in that reconstruction, the strengths of the prosecution's case, and any other facts regarding fairness. Next, we have Drope v. Missouri from the U.S. Supreme Court in 1975 that talked about under what circumstances should a defense counsel raise the competency issue. And in this case, Mr. Drope was charged with raping his wife, and the defense counsel asked for a competency evaluation because there was testimony from a psychiatrist that the defendant was ill. There were statements from the victim herself that the defendant was acting strangely. And then we have on the second day of trial, the defendant shot himself. And the judge ruled his absence from trial was voluntary and proceeded with trial. He was convicted. So he appealed that, saying that the court should have stopped the proceedings and should have raised the competency issue. And so they said basically that his strange behavior at trial, his attempted suicide, and the testimony of a psychiatrist should all have triggered a competency evaluation. We have Cooper v. Oklahoma from the U.S. Supreme Court in 1996 that talks about what's the standard of proof required to prove incompetence to stand trial. The court held that the proper standard is a preponderance of the evidence. I think at that time 4 states required clear and convincing evidence to prove incompetence, but that was found to be improper. And finally, we have Indiana v. Edwards, which gets to the standards for competence to stand trial and competence to go pro se. And in Indiana v. Edwards in 2008, the court reinterpreted their earlier ruling in a 1993 case called Godinez v. Moran. In that case, the court ruled that it's basically the same standard for competence to stand trial as it is for competence to go pro se. So 25 years later, the Supreme Court revised their ruling in the Edwards case, saying that a different standard is allowed for competence to go pro se compared to competence to stand trial. Of course, the court didn't define what that standard is, which would have been helpful. And they also said, though, a state may require an otherwise competent defendant to proceed to trial with the assistance of counsel. So it doesn't let them go pro se automatically. Now in Ohio, we have this strange thing called ISTUCJ. As far as I know, we're the only state that has this. And this was part of the Get Tough on Crime law Senate Bill 285 passed in 1997. There was several different elements of that Senate bill, but it created this CJ status. So when a defendant is found to be incompetent to stand trial and unrestorable on a violent F1 or F2, the prosecution may make a motion to label the defendant a CJ. CJ means court jurisdiction. And the prosecution makes that motion, even though the defendant is incompetent, the court will proceed with a mini trial to determine is there clear and convincing evidence that the defendant committed the offense. Not for the purposes of guilt, but for the purposes to determine should they label them as a CJ. So, and if so, then if they're labeled a CJ, then their case is retained in the trial court. They are committed, civilly committed in the trial court, not the probate court, and the trial court retains jurisdiction over them. So they basically get the same treatment as someone who's found to be legally insane, that their case is retained in the trial court, and when they are discharged from the hospital, they don't get an outright discharge. Instead, they get a conditional release that the court has discretion to authorize. And this was upheld in 2011 by the Supreme Court of Ohio in a case called State v. Williams. So this gets to our pretest question here about someone who's incompetent and fails restoration, unrestorable, can still proceed to, it's not really a real trial, but a trial to determine should it be labeled as a CJ. All right, let's talk about the top 20 errors in competency evaluations. So number 20, equating someone who's ignorant about something, about how the courtroom works, with incompetency. So lack of knowledge has to flow from a present mental condition, not just lack of knowledge. 19 is to minimize the impact of a single delusion. You can have a defendant who passes every area of competency successfully, but if they have a single delusion, for example, that their attorney is Satan, or that God is going to come down and prove them innocent and there's no reason for them to work in their defense, that can render them incompetent. 18 is to equate having a mental illness with incompetency. It's not automatic that someone who's mentally ill is also incompetent. 17 is giving ultimate issue testimony. 16 is equating incompetence in one area. So, for example, someone who has a guardian with incompetence in other areas. There's different legal standards for all these different types of competency, and they all require their own separate examination. 15, not knowing the actual competence to stand trial standard. 14, not actually doing a specific competency assessment. 13, confusing insanity with competency. Not looking at medical records. Confusing the various types of competency. Failing to address restorability. 9, and sometimes this happens, making up your own standard. That's not a good practice. Failing to consider that deficits are not due to a present mental condition, but due to other factors. Again, ignorance, free man beliefs, etc. 7, failing to perform a mental status examination and therefore missing symptoms. 6, having an overly rigid and high standard. Well, just because the guy didn't know he is facing, 18 to 20 years, finding him incompetent because he doesn't know that exact information. You don't have to know it to that degree. 5 is failing to evaluate their decision-making capacity. 4, failing to consider malingering. 3, equating amnesia with incompetence. 2 is stating the opinion but not using the language and the standard. And 1 is the big one, so not explaining your rationale for your opinion. All right. Any questions on competence to stand trial since we're on this topic? Yes?
I have a general question that I think might tie in briefly to the illusion case that you mentioned, but I'm seeing an influx in defendants with traumatic brain injuries, maybe resulting from incidences at prison or jail or even overseas during the war. So they have their own separate issues in regards to retaining information, recalling information prior to the brain injury. Have you seen an influx in sort of referrals for competency evaluations on that unique population of people?
I have not, no. we certainly get those referrals. We get referrals for people with TBIs, but I have not seen it since, uptick in recent years. I don't know. Meg, have you seen that at the court clinic, an uptick in referrals for competency based on TBIs?
I haven't seen it. I do a little bit at Northwest, but I haven't seen it.
Okay. Yes?
On the statute that you mentioned about competency evaluations not being used, statements made for guilt and so forth, does that preclude the use of any and all statements made in competency evaluations, particularly for 404B, evidence, lack of mistake, intent, motive, opportunity, things like that? Can statements come in under the evidence rules that may not otherwise come in under the competency statute?
That's a good question.
Well, that's what the prosecutor was doing in my case.
Yeah, I would say that, this is just my experience, that other information can come in, for example, from the defendant's social history or his educational history, if it's not being used to prove guilt specifically.
Well, since a competency evaluation is to understand the nature of proceedings and assist in a person's own defense, why are competency evaluations, why do they even go into the history and those sorts of things? If they're not, I'm going to counsel always my clients, don't tell them anything about your background, which is going to skew the diagnosis, because I don't want that evidence come in.
But I wouldn't advise that, because in order to do a thorough evaluation and to make an accurate diagnosis, we generally need to ask those background issues.
Which can then come in and hurt the client at trial.
May or may not. It also might help with mitigation. Who knows? Well, let's go on briefly to talk about other types of criminal competencies here. So competence to confess. So like all of these competencies, it's the standard for waiving any constitutional right. So was it knowingly, intelligently, and voluntarily waived? And we get involved in this retrospectively, not so much with the voluntariness, but rather did the defendant, due to psychosis, mania, low IQ, intelligently and voluntarily waive his Miranda rights and confess? So that's one issue that comes up. Other issues with this, using the same standard, competence to plead guilty, competence to waive counsel, all is that knowing, intelligent, and voluntary standard. We had a case back in the Rise of Fellow about waiving appeals, where a defendant was on death row, and he wanted to waive all of his automatic appeals and proceed directly to execution. So the question was this an expression of his depression and possible psychosis versus a competently made decision? It's a case called Wilford Lee Berry. And turns out that Mr. Berry was actually making a competent decision. He certainly preferred to be in freedom, hated prison, and was deciding that he just didn't want to stay on death row for 10 more years while all of his appeals were filed because he hated prison so much. This wasn't a reflection of any kind of mental health symptom, but wanted to proceed to execution. And so the court agreed. Competence to be sentenced. I'm going to skip through some of this here just in the interest of time here. Here's the competence to waive appeals here. They have to be able to rationally make a decision whether to pursue their appeals and be able to assist their counsel in that pursuit. And finally, competence to be executed. Now, 31 states currently have capital punishment, and the average length of time between a capital sentence being given and execution is 15 years. In some states, I had a case a couple years ago where a defendant was on death row for 30 years. So the point is that even if there's not a mental health issue at the time of trial, during all those years on death row, there's the potential for a mental illness to develop that would then impact their competence to be executed. So this can get raised, and these are the things we look at in general for competence to be executed. And there's some case law on this. It's a case called Ford v. Wainwright and then Panetti v. Quarterman that talk about this. Juvenile competencies. Juveniles also have the right to be competent to bind over hearing in a trial, and the standard here was developed in 2011, very similar to the adult standard. So if due to a mental illness, developmental disability, or otherwise lack of mental capacity, the child is incapable of understanding the nature and objectives of the proceedings against the child or of assisting in their defense. So a Dusky standard very similar to the adult standard. All right. The next section will be NGRI. Should I start or should we stop?
Probably stop. We've got 3 minutes before the lunch break. Is that okay? Will you be all right?
Tell you what, let me do about 5 slides and we'll stop because I think I can get through this here, okay? So NGRI is a affirmative defense. As you know, this is where a defendant affirms the commission of the actus reus, but they assert that they are not liable, either because they say the actus reus was not illegal or because of special circumstances they are not blameworthy. And so a defendant who raises an affirmative defense then bears the burden of proving the existence of this affirmative defense. In Ohio, it's by a preponderance of the evidence. And you can break down these affirmative defenses into justification defenses. Most common is self-defense or excuses. So not guilty by reason of insanity is the most common excuse defense. And why don't we stop there? So I'll see you at 1 o'clock.